Start. When a court is considering whether punishment of termination from service imposed upon a bank employee is shockingly excessive or disappropriation to the gravity of the proved misconduct, the loss of confidence in the employee will be an important and relevant factor. When an unknown person comes to the bank and claims to be the account holder of a long inoperative account and a bank employee who does not know such person instruct his colleague to transfer the account from dormant to operative category in bracket contrary to instruction regulating dormant account bracket close without any kind of verification and accept the money withdrawal from such person, gets a token and collect the amount on behalf of such person for the purpose of handing it over of such person, he is effect enable such unknown person to withdraw the amount contrary to the banking procedure, and ultimately if it transpire that the person who claimed to be account holder was an impostor, the bank cannot be found fault with if it says that it has lost confidence in the employee concerned. A bank is justified in contending that not only employees who are dishonest but those who are guilty of gross negligence are not fit to continue in its service. Several witnesses were examined to prove the charge. One of them was H.S. Sharma, who conducted the preliminary inquiry and to whom the respondent had made a statement broadly admitting the fact which constituted the subject matter of the second charge. Mr. Rawal, who was the cashier, and C. Ojha, the officiating branch manager, were also examined. Based upon their evidence, the inquiry officer found the respondent to be guilty of the second charge, and that has been accepted by the disciplinary authority. The High Court has interfered with the said finding without expressly holding that the said finding of guilt was erroneous. The High Court has proceeded as if it was sitting in appeal over the departmental inquiry and interfered with the finding on a vague assumption that the respondent must have acted bona fide in an increasing customer-friendly atmosphere. There was no justification for the division bench to interfere with the finding of guilt. The fact that the criminal court subsequently acquitted the respondent by giving him the benefit of doubt will not in any way render complete disciplinary proceeding invalid nor effect the punishment. The standard of proof required in criminal proceeding being different from the standard of proof required in departmental inquiries, the same charges and evidence may lead to different result in the two proceeding, that is, finding of guilt in departmental proceeding and an acquittal by giving benefit of doubt in the criminal proceeding. This is more so when the departmental proceeding are more proximate to the incident in point of time when compared to the criminal proceeding. The finding by the criminal court will have no effect on previously concluded domestic inquiry. An employee who allow the finding in the inquiry and the punishment by the disciplinary authority to attain finality by non-challenge cannot after several years challenge the decision on the ground that subsequently the criminal court has acquitted him. We are therefore of the view that the High Court was not justified in quashing the punishment and directing the departmental to take action for restoring his welfare. Para. We have noticed at some length the sequence of events and the effort made by the respondent to receive copies of the document which were relevant for the preparation of his defense in the departmental inquiry. Stop.